Okay, welcome everyone. Thank you so much for attending. I think we're going to go ahead and get started. I do want to note that this webinar is being recorded and will be available on our website to view after the fact. Thank you for coming to A Better Balance's Know Your Rights Primer for working parents. Rachel, can we go to the next slide? Thank you. I am Megan Racklin. I'm a staff attorney at A Better Balance, and I'll be one of the presenters today. My colleague, Cassandra Gomez, another staff attorney at A Better Balance, is with us as well. And we also want to thank Rachel Sika for helping us facilitate this presentation. Can we go to the next slide? So A Better Balance, as some of you may know, is a national legal advocacy organization. We have offices in New York City, where Cassandra and I are based, and in Nashville, Colorado, and Washington, D.C. And our goal is to leverage the power of the law to make sure that workers can care for themselves and their loved ones without sacrificing their economic security. That means that we work across a range of issues, from pregnancy discrimination and accommodations to caregiver discrimination, paid family and medical leave, paid sick time, LGBTQ rights and family recognition, and really the whole spectrum of issues that make sure that people can really take the time that they need and have the support that they need to care for themselves and their families while earning a paycheck. You can find a lot more information on our website, and specifically for information about rights under various laws in different states, you can go to the Know Your Rights section of our website. You can see the link in the top right-hand corner on these slides. And if you have questions about your own rights, you can always call our free confidential legal informational helpline. The number's right up top as well. Can we go to the next slide? So the reason that we're having this webinar today is because we know that children across the country are starting to return to school, and working parents are left navigating the uncertainty that this time brings, given potential surges in COVID cases and just a lot of ongoing uncertainty around the pandemic, in addition to the questions that might come up in any back to school season for working parents. We are fighting to improve our nation's infrastructure of supportive workplace laws for families. And we know that it's more important than ever for parents to understand what their rights are in this really uncertain time. We know it's nearly impossible to plan for unexpected illnesses or injuries and the kind of host of things that might come up, but we think it's really important for people to know their rights as best as possible, so that when things do come up, they're prepared to take the time that they need and ask for the things that they need at work, to the extent that those protections exist. I also want to mention, since we're going to cover a lot of ground today, that there's a Q&A box that you can find at the bottom of your Zoom screen. If you have questions, we can answer some of those questions at the end of the presentation. So please just feel free to add your questions to that box so that we can come back to them later. Can we go to the next slide? We today are going to cover a lot of the things that might come up for parents as the pandemic continues at the start of the 2021 school year. That, as I said, is going to entail a range of types of laws that we're going to cover. Can we go to the next slide, Rachel? So specifically, we're going to talk about laws that might apply to you if you need time off from work, for instance, to get vaccinated, or if you need longer or shorter periods of time off for your own health or to care for a loved one. We're also going to talk about laws that might apply if you need flexible work or scheduling modifications or workplace accommodations for pregnancy or disability, as well as anti-discrimination laws, especially as they apply to caregiver status and to race, sex, and disability. Can we go to the next slide? Okay, great. So I'm going to turn it over to Cassandra now to talk a little bit about laws that might apply to you if you need to take time off from work.
Thank you so much, Megan. And thank you everyone for joining us today. So now we're going to get into it and talk about taking time off from work. So in general, the types of time off that we're going to talk about fall into two categories: time off from work for a short period of time and time off from work for a long period of time. And for that first category, we'll talk about a few different types of leave. So for example, vaccination leave, paid sick time, and emergency sick time. And for the second category, we'll talk about family and medical leave. If we can switch over to the next slide. So I'm going to start with a big update. Earlier this month, it was announced that OSHA will issue an emergency temporary standard in the coming weeks, which will require large employers with 100 or more employees to give their employees paid time off in relation to the COVID-19 vaccine. And while we don't have the details of the new emergency rule just yet, it will likely cover time off to get yourself vaccinated, to recover from immune responses in relation to the COVID-19 vaccine, and to help your family members get vaccinated. And our website will have more information about your rights under the new rule when OSHA has published it. And the best place to find information about this will be our Know Your Rights Guide to COVID-19 vaccination leave. And switching over to the next slide. So in the meantime, many states and localities already have laws that give workers paid time off to receive the COVID-19 vaccine, recover from any immune responses from the COVID-19 vaccine, and help family members receive the vaccine. So for example, if you need to take a day off to rest after you've gotten the vaccine, or if you need to take time off to help your high schooler get vaccinated, you may be entitled to take paid time off. The latest information on which states and localities have vaccination leave laws is available at our Know Your Rights Guide to COVID-19 vaccination leave on our website. And since these laws are pretty new, they really vary in what protections they offer, like the amount of time off that you can take and what you can take time off for exactly. So check out our website for more information. And if we move forward, we'll talk, so while we're talking about vaccination leave, I also wanted to briefly mention the work that A Better Balance is doing to make sure that cities, counties, and school districts nationwide can protect their communities while the COVID-19 pandemic is ongoing. So something that we're seeing across the country is that states are blocking cities, counties, and schools from enacting certain measures using something that's called preemption. So in particular, preemption has recently been used to block, for example, health measures like mask mandates, vaccination requirements, and also just general local public health authorities from taking protective action. So, for example, the governors in Florida and Texas issued executive orders prohibiting schools from issuing mask requirements. And while many of these laws are being challenged in court, they may undermine workplace protections and common sense public health policies. Some of our colleagues work very closely with the Local Solutions Support Center and have put together many resources on COVID and preemption, and you can find those on our website's Defending Local Democracy page. Now, moving forward to this next slide here, we're going to talk about paid sick time. So several states, cities, and counties nationwide have paid sick time laws, which give covered workers the right to earn paid sick time to care for themselves or a family member. And in general, sick time under these laws can be used when you or a family member are sick, hurt, or getting medical treatment, including mental health and preventive care. In many places, you can also use your sick time to address the impact of domestic or sexual violence. So for example, if you wake up in the morning and your child has a sore throat and can't go to school, you may be able to take paid sick time to care for them. Or if you need to go to a doctor's appointment, paid sick time may also be an option. And if you're covered by a paid sick time law, you can also use your earned paid sick time to receive and recover from the COVID-19 vaccine. Our website has a map of all the jurisdictions that have paid sick time laws on the books. And we also have Know Your Rights articles that break down what you need to know about each of these laws. And you can find more information about your paid sick time rights under our website's paid sick time page. Now, if we go over to this next slide, in particular, I wanted to note the following jurisdictions, which give paid sick time laws which have paid sick time laws that have closure provisions. So, which may give you the right to use paid sick time when your workplace or your child's school or place of care is closed because of a public health emergency. So this will be particularly important to keep in mind as more schools open for the year and as more workers head back to work. So for example, you'll see Colorado listed right here. So in Colorado, if your child's school has closed because of a COVID outbreak, you may be able to use your paid sick time under the permanent paid sick time law. Now here we'll start talking about emergency sick time. So the laws that we just talked about are permanent and give workers permanent paid sick time rights. But emergency sick time laws, which many states and localities have enacted in response to COVID-19, for the most part are temporary, and many will expire soon on September 30th. But these laws have given workers the right to take paid time off for purposes related to COVID. Emergency sick time is in addition to earned sick time, and it isn't earned over time, but instead you can use it immediately. And it can generally be used when you or a family member are sick with COVID or need to quarantine or isolate because of COVID exposure. And in many cases, workers can use their emergency sick time in relation to the COVID-19 vaccine. But rights under these laws really vary a lot depending on where you work. So for example, some workers may only be entitled to unpaid emergency sick time or emergency sick time paid at a lower than their typical rate. And just to reiterate, while the laws may be extended, many of them will expire soon on September 30th. So here's a list of jurisdictions with emergency sick time laws on the books. So you'll see, for example, in California, there's a statewide emergency sick time law, as well as several local emergency sick time laws. And A Better Balance has been tracking these laws throughout the pandemic and will continue to update our resources for the latest information on emergency sick time rights. And you can take a look at our emergency paid sick leave tracker on our website where we post all of these. And now we're going to start talking about paid family and medical leave. So we just finished talking about time off from work for short periods of time. So we're switching gears and talking about time off from work for longer periods of time. So paid family and medical leave is usually for a period spanning several weeks and can be for up to a few months. And in particular, paid family and medical leave can be used when you have a serious health condition, when you need to bond with a new child, when you're caring for a seriously ill loved one, or if you have certain military family needs. So for example, if you need leave from work to care for your parent who is sick with cancer, you may be able to take paid family and medical leave. Or if you need to take time off because you're having a baby or adopting a child, you may also be able to take paid family and medical leave. And depending on your circumstances, COVID-19 may also be considered a serious health condition for leave purposes under many of these laws. Moving on to this next slide. While the details of each program vary, generally state paid family and medical leave programs are social insurance programs that are paid for by regular payroll contributions from workers and employers. So this is a list right here of the states with paid family and medical leave laws. So you'll see that this first list up top in Rhode Island, California, New York, DC, Washington State, and Massachusetts, the paid family and medical leave programs are up and running, meaning that covered workers in those states can apply for and receive paid family and medical leave benefits. And then in the second paragraph below here, you'll see that Connecticut, Oregon, and Colorado have paid family and medical leave programs that will begin paying benefits to workers in 2022, 2023, and 2024, respectively. And though specific rights may vary, many workers are entitled to have their jobs back when they return from leave. So for more information about paid family and medical leave, which are important and complex laws, you can visit our Know Your Rights hub on our website. So workers may be able to take family and medical leave under another law. This is a federal law now that we're talking about, called the Family and Medical Leave Act, or the FMLA. So the FMLA provides covered workers up to 12 weeks of unpaid leave to bond with a new child, address the worker's own serious health conditions, care for certain family members with a serious health condition, or address certain military family needs. And I also want to note that unlike state paid family and medical leave laws that we just talked about, leave under the federal FMLA may be unpaid. And workers covered by the FMLA have the right to return to the same job after returning from leave. If the same position isn't available, you have to be placed in an equivalent one. And I also just want to note while we're here that workers may take up to 26 weeks of FMLA leave to care for a military service member with a service-connected injury or illness. But again, this is another complex law. So for more information, you can visit our Know Your Rights hub on our website, which gives a really great overview of what rights you may have under all of these laws. And so now I'm going to turn it over to Megan.
Thank you, Cassandra. So now we're going to talk a little bit about laws that might apply to you if you don't need time off from work necessarily, but you do need some changes to the way things are working on your job, at your job. So first, I want to talk a little bit about laws that might apply if you need a fair or flexible work schedule. So imagine, for instance, a worker who is scheduled to start an early shift, like they typically work an early shift. Maybe it starts at 7 in the morning or even earlier. They know their child's going back to school soon and that school starts at 7:30. And so the start time of their shift is making it really difficult for them to negotiate dropping their child off at school. A worker in that scenario might want to request a later start time from their employer. Or alternatively, you could imagine a worker who doesn't get a lot of notice of what their schedule is even going to look like. Maybe they get 24 hours notice or less of when their next shift is going to be and what time that shift is going to start and end at. They know their child's going back to school and that school gets out at 3 in the afternoon. They don't know, because of this uncertainty about their schedule, whether or not their child's going to need after school care, and they're concerned about the cost of after school care that they may or may not need. So they might want to request more advanced notice of their schedules so that they can really make sure that they're only putting their child in after school care when that's really necessary. These are some of the situations where workers might want some protections around requesting or receiving fair and flexible work from their employer. Can we go to the next slide? We know that this is something that workers across the income spectrum around the country struggle with. In a lot of industries, especially for hourly workers, there are just really unpredictable hours, really rigid or inflexible schedules. And we are really working hard to make sure that workers have fair and predictable schedules. Unfortunately, there isn't a general federal law concerning the right to fair and flexible work schedules. There are some federal laws, including the Americans with Disabilities Act and the Pregnancy Discrimination Act, which we'll talk about a little bit later, that might give some workers the right to reasonable accommodations. And a reasonable accommodation could include a fair or flexible schedule. But again, there's no law that generally gives workers rights related to fair and flexible scheduling. Several states and localities have laws that do give workers some protections in this regard. Some of these laws give workers things like the right to advance notice of their schedules, or the right to request a schedule change without fear of retaliation, or even the right to receive a schedule change if it's manageable for their employer. You can find more information about those state and local laws on our website. We have a fact sheet that's a guide to fair and flexible work in states and localities. You can also find more information in our Know Your Rights hub, which again is linked at the top of the right-hand corner, betterbalance.org/know-your-rights. That has guides to laws that apply to workers in each individual state. So if you have more questions about what rights might apply to you, you can go there and look at your particular state to see if there's laws that might apply. Can we go to the next slide? I also want to talk a little bit about anti-discrimination laws that might be relevant to working parents. So first, I want to talk about caregiver discrimination. So just to give a couple of examples, imagine, for instance, that an employer decides not to promote a particular employee because they know that that employee is a caregiver for their young child. And as a result of that information, the employer just assumes that that employee isn't going to be dedicated to the new position. So instead, they promote an employee who doesn't have caregiving responsibilities. That's an example that could be considered caregiver discrimination, but unfortunately, there's no federal law that prohibits caregiver discrimination in and of itself. There are several states and cities that have passed laws prohibiting discrimination against caregivers. Can we go to the next slide, Rachel? So states that have laws on the books prohibiting discrimination based on caregiver status, familial status, marital status, family responsibilities, or similar include the ones listed here. These terms have varying definitions in different states. Some of them only protect people who, for instance, are parents. Some protect people who have caregiving responsibilities to their own child or another care recipient, such as potentially an elderly parent or things of that nature. There's also a number of cities and localities that have laws preventing this type of discrimination. Again, there's a fact sheet with more information available on our website, and all of this is laid out in more detail on our Know Your Rights hub in that state-by-state breakdown. So I also want to talk a little bit about some laws that might be relevant to caregivers, even though, as I already said, there's no federal law prohibiting caregiver discrimination in and of itself. So imagine, for instance, if an employer was excluding female employees with young children from morning meetings, but they're continuing to include male employees with young children. That could be an example of sex discrimination. Another example could be if an employer is granting female employees requests for flexible schedules to accommodate their childcare needs, like if they want to be able to come into work an hour later to accommodate school drop-offs. But if that same employer is denying those kinds of flexible work requests from male employees, that also could be an example of sex discrimination. There is a federal law that makes it illegal for any employer in the US with 15 or more employees to treat employees unfairly because of their sex. I want to note, I think this is really important, that discrimination because of gender identity, including transgender status, or because of sexual orientation, is discrimination because of sex under this federal law. So discrimination based on sex means a change in the terms or conditions of employment based on sex. So that could mean something like being fired or not being hired, not being considered for a promotion, not getting as favorable work assignments or shifts, things like that. If those kinds of things are happening because of someone's sex, including their gender identity or sexual orientation, that could potentially be sex discrimination. And this can, and this is the point I really want to emphasize here, this can include certain types of caregiver discrimination when it's linked to sex. So if an employer is excluding all caregivers of any sex from morning meetings and including everybody who's not a caregiver, that wouldn't necessarily be sex discrimination. But in the example we talked about earlier, if the employer is only excluding female caregivers from morning meetings and is still inviting male employees with caregiving responsibilities to those meetings, that could be an example of sex discrimination. I also want to talk about race discrimination here. So as an example, consider an employer who allows white female employees to use comp time for childcare needs, like to take an hour or two here and there to pick their child up from school if their child has to go home sick or something of that nature, but is refusing the same kinds of requests from Black female employees. That could be an example of race discrimination. There is a federal law that makes it illegal for any employer in the US with 15 or more employees to treat their employees unfairly because of their race. So just like with sex discrimination, that means if an employer is making decisions about hiring or firing or about promotion or career advancement or more favorable assignments based on race, that's potentially race discrimination in violation of federal law. And I think it's really important to note that caregivers of color may face intersectional discrimination. So like in the example we just discussed, women of color with caregiving responsibilities may face discrimination that their white counterparts are not facing because of overlapping forms of discrimination. So for example, even if there were a federal law prohibiting caregiver discrimination, which as I really want to make clear, there unfortunately is not, although there may be state or local laws that do. Caregivers of color may still be treated differently than their white counterparts. And so this race discrimination law would still play a really important role in making sure that intersectional forms of discrimination are addressed. I also want to talk about disability discrimination and what's called associational disability discrimination. We'll talk a little bit more about what that means in a minute, but just to give some examples first. If an employer is refusing to allow an employee with a disability to work remotely, even though they're allowing other employees who don't have disabilities to work remotely, that could be an example of disability discrimination. Another example could be if an employer is refusing to allow an employee with a disability who needs to work remotely in order to manage their disability during the ongoing pandemic. And that employee could actually do their work remotely without it being really difficult or expensive for the employer. That could be disability discrimination as well. And then, and this is the part that's associational disability discrimination, if an employer is, for example, refusing to consider an employee who has a child who has a disability for a promotion because they're assuming, based on stereotypes about people with disabilities, that employee is going to be too busy with caregiving responsibilities or not committed enough to the job to handle the new role, that could be an example of associational disability discrimination. So there's a federal law that makes it illegal for any employer in the US with 15 or more employees to treat their employees unfairly because they have a disability. This law also requires covered employers, so that's employers with 15 or more employees, to provide reasonable accommodations for employees with disabilities. That means they have to make kind of modest adjustments to the job to accommodate their employees with disabilities, as long as it's not really, really difficult or expensive for them to do so. So that could mean providing some modified equipment. It could potentially mean a change in schedule or other kinds of changes to the job that an employee with a disability might need to be able to continue to do their job. And again, employers have to provide those to employees with disabilities as long as it's not really difficult or expensive for them to do so. The same law also prohibits employers from discriminating against an employee because of their association with a person with a disability. So that's associational disability discrimination. So whether or not an employee has a disability, if they have a relationship with a person with a disability, such as a child, a spouse, or a parent, an employer can't discriminate against that person because of that relationship, because of the kinds of assumptions or stereotypes they might have about what it means to have a relationship with a person with a disability or care for a person with a disability. It's really important to note, I think, that the law doesn't require employers to make reasonable accommodations for people who have a relationship with a disability. So if an employee has a disability themselves, an employer has to make those reasonable accommodations, those modest adjustments on the job for that employee, as long as it's not really difficult or expensive. But an employer doesn't have to make those kinds of adjustments for an employee who has a relationship with a disability. They just can't treat them unfairly because of that relationship. I do want to briefly touch on pregnancy discrimination and some issues related to lactation in the workplace. We know that a lot of parents with school-age children might also be navigating pregnancy while at the same time navigating the kinds of things that come up when caring for school-age children. We also, around this time of year, tend to get a lot of questions from school employees who might be navigating pregnancy and lactation on the job. So I do want to just touch on this quickly. An example of pregnancy discrimination could be if an employee announces that they're pregnant and then their employer fires them because they assume that after they give birth, that employee is not going to continue working. That could be an example of pregnancy discrimination. And there is a federal law that makes it illegal for any employer in the US with 15 or more workers to discriminate against an employee because they're pregnant. The federal law that we just talked about, the Americans with Disabilities Act, also requires employers to make reasonable accommodations for pregnancy-related disabilities. So like we talked about, the Americans with Disabilities Act requires employers to provide reasonable accommodations for employees with disabilities. That includes employees with pregnancy-related disabilities, like, for example, gestational diabetes or placenta previa. You can find a lot more information about this on our website. And again, you can find more information about how this might apply to you on our Know Your Rights Hub. We also have a specific resource on as a Know Your Rights guide to COVID-19 and pregnancy. If you do not have a pregnancy-related disability, then there isn't a federal law that gives you a direct right to reasonable accommodations. But under the federal law that says that employers can't discriminate against pregnant workers, you should be given the same ability to seek accommodations as is given to any other employee. So your employer can't treat you differently, which means that if other employees are allowed to modify their schedule or take like to take smoking breaks, for example, you should be allowed to modify your schedule for pregnancy-related needs. Similarly, if other employees are able to receive alternative assignments to accommodate temporary illnesses, the same kinds of accommodations should be provided to pregnant workers who have needs that would require an alternative assignment. Some examples of reasonable accommodations that pregnant workers might need might include the ability to sit occasionally, to carry a water bottle with them, to limit their lifting temporarily, to request to telework. It could really be a variety of things. This is just some examples. There are 31 states and 4 cities that have passed laws that give pregnant workers a clear right to reasonable accommodations, whether or not they have a disability. These laws are often passed with bipartisan, even unanimous support. And this map shows where those laws exist. You can find a lot more information on the Pregnant Workers Fairness page of our website, and again, on our Know Your Rights Hub. There is also a federal law that provides a right to break time and space for employees who are lactating and need to pump breast milk. It covers employees who are non-exempt under the Fair Labor Standards Act, and it says that employers have to provide these employees with a reasonable amount of break time and space, a space that's not a bathroom, to pump breast milk for up to a year following the birth of the employee's child. There's a possible exemption for employees with employers, with fewer than 50 employees, if it would be really difficult or expensive for them to provide that break time and space. There's a number of states with additional protections for people who are lactating at work. And we have a resource on our website called Talking to Your Boss About Your Pump that gives a lot more information. And this information, again, is also available in our Know Your Rights Hub, which is linked at the top of the page. I'm going to turn it back over to Cassandra to talk a little bit about retaliation.
Thanks, Megan. So all of the anti-discrimination laws that Megan just talked about have anti-retaliation protections, meaning that you can't be punished or retaliated against for things like filing a complaint or requesting an accommodation in relation to a disability. So taking a close look at this list, some of the things that you cannot be punished for or retaliated against for, filing or being a witness in a charge, complaint, investigation, or lawsuit, communicating with the supervisor or manager about employment discrimination, including harassment, answering questions during an employer investigation of alleged discrimination or harassment, refusing to follow orders that would result in discrimination, resisting sexual advances or intervening to protect others, and requesting accommodations for a disability, including a pregnancy-related disability. And many of the paid leave laws that I went over earlier provide similar anti-retaliation protections so that you can't be fired or punished for using your paid sick time, for example. And so many of the resources that we mentioned today are available on our website at abetterbalance.org/know-your-rights and abetterbalance.org help.org/COVID-19. And we're constantly updating our resources and posting new resources to help workers understand their rights, particularly as laws evolve in response to COVID-19. So definitely take a look at our website for the latest developments. And going on to this next slide. If after hearing this primer today, you'd like to get involved in making sure that parents across the country have access to paid sick time, paid family and medical leave, fair and flexible scheduling, and reasonable accommodations for pregnancy and breastfeeding, sign up for our mailing list and follow us on social media to learn more. All of our handles are listed here, and we're constantly working on ensuring that workers have more rights available to them across the country. And moving on, in addition to our Know Your Rights resources that we've gone over in good detail today, A Better Balance operates a free and confidential legal helpline where workers nationwide can talk through their workplace rights with one of our lawyers on the ABB team. And you can give us a call at 1-833-NEED-ABB or visit abetterbalance.org/get-help to reach the helpline, where we offer assistance in English and Spanish. And just on this next slide, we wanted to say thank you. We went over a lot today. Thank you so much for tuning in. We really appreciate you. And now turning it over to this last slide, we just wanted to open it up for questions. So if you have any questions, we are happy to go over them. As I said, we went over a lot today pretty quickly, and we have a good amount of time left if anyone has any more questions for us. So I do see a question in the chat about how these laws are great. Agree with you there, Jane. How often are they actually effectively applied? For example, so here's an example where you're let go 6 weeks into FMLA by an employer. I'm so sorry to hear that, Jane. Consulting with a lawyer. Yeah, so reading this situation in particular, so the FMLA does offer job protection, which I talked a little bit about today when we were going over the FMLA. When there is something like a class-wide layoff, or it sounds like your employer said that they were restructuring the department, in instances where the employer is able to genuinely show that the worker who's on leave, their position is in whatever way or for whatever reason being eliminated for a reason that does not ultimately come down to something like retaliation, then in those types of instances, unfortunately, the FMLA has been interpreted in the court system to find that workers are not eligible for their jobs back in those situations. And these laws tend to be, so for example, for the FMLA, workers are able to enforce their rights in court, but it can be sticky with those types of situations where the employer genuinely has, for example, like a layoff or a restructuring. So I'm very sorry to hear about that, Jane, but thank you for letting us know.
And I would also say, if you have more questions about your specific situations, and often it really depends on what's happened in anyone's particular case, definitely call our helpline or get in touch with our helpline on our website, and someone can get in touch with you to talk you through a little bit more about what might apply specifically to your situation. We have another question from Laura. These laws only apply to employers with 15 or more employees. Does that mean that there's nothing to do if there's less employees? So first, I just want to clarify that the 15 employee threshold is largely applicable to the federal anti-discrimination laws that I talked about. The Paid leave laws, paid and unpaid, I should say, that Cassandra talked about have different requirements, but for anti-discrimination laws, I think it's important to keep in mind that the laws that we covered in more detail today are federal laws. States and localities often have a number of additional laws that provide protections for people in those states and localities. And often, not always, but often, state or local anti-discrimination laws have a lower employee threshold. So in some states, there may be, for instance, a law prohibiting sex discrimination that applies to employers at smaller employees than the federal law covers. So if you want more information about your specific state and the types of anti-discrimination protections that are available there, that's all available in our Know Your Rights Hub at abetterbalance.org/know-your-rights.
And just to piggyback off of that, to be clear, a lot of the leave laws that we talked about, they vary from place to place, jurisdiction to jurisdiction. There may be particular parts of the leave law that only apply to employers of a certain size, but many apply all of the requirements and all of the protections to employers regardless of size and workers regardless of their employer size. So it's really tough to give like a super detailed answer about exactly what paid leave rights you have, just because we're kind of giving a broad overview here of the entire country. But definitely take a look at the Know Your Rights Hub that Megan mentioned. It's also right there in the upper right-hand corner, because it goes in detail for each state, which laws apply at the state level and at the local level, and what your rights may be depending on things like employer size. So please take a look for more information. All right, well, we got through all of that in good time, but unless any other folks have any questions, just want to reiterate how many resources we have available to workers and parents, which will be super helpful as we continue to navigate this pandemic in particular. And yeah, definitely our helpline is available to help explain any of these laws that we went over today, 1-833-NEED-ABB. Thank you so much.